Hello, welcome to this introduction to appellate advocacy for students participating in the Reverend Joseph T. Tinnelly Moot Court Competition at St. John's Law School. The Tinnelly competition is the entry-level moot court competition for students wishing to join the Moot Court Honor Society. In this video, I wanted to do three things. The first is to give you an overview of the appellate process, how judges decide appellate cases, and how moot court differs from practice in the real world. Next, we'll talk about oral argument, what its purpose is, what the mechanics are, as well as some strategies for delivering an effective oral argument. And then finally, how to develop an outline for your oral argument in the Tinnelly competition. So we'll begin with just a reminder of where appellate courts sit in the overall process in litigation. Ordinarily, in 99.999% of cases do not start at the do not start at the appellate court level. Instead, they start at a trial court level. From there, the case proceeds to an intermediate appellate court and then finally to the highest court in the jurisdiction. So in the federal system, that's the U.S. District Court, then the U.S. Court of Appeals, then the Supreme Court of the United States. In New York, we have a little bit of a different system. We start off at the Supreme Court, then go to the Appellate Division in most cases, and then the New York Court of Appeals. This is important in order to understand appellate process, particularly in the real world. In the real world, an appeal always starts with something happening at the trial level. There's perhaps a hearing, or there's a motion for summary judgment, or there's even a full trial. But the point is, something happens at the trial level that then causes one of the parties to feel or believe that they are aggrieved. And so they file an appeal. Typically, that has to happen at the end of a case. That's the finality rule in appellate process. Typically, appeals courts don't want to hear cases that are sort of in the middle of being litigated. New York is a bit of an exception. New York allows a lot of what we call interlocutory appeals. But in general, in the federal system, you have to wait for the whole process to play out at the trial court level before a party may appeal. The losing party at the trial level can file a simple document known as the Notice of Appeal. That's what starts the appellate process. From there, the party appealing, which we call the appellant, has to order transcripts and collect together the record, meaning all of the documents that are relevant to deciding the appeal. After that's done, the appellant files a brief, which is a persuasive written document trying to convince the appellate court to reverse or adjust the trial court's ruling. The appellant files that brief, which can be quite lengthy. It could be 50, 70, even 100 pages, along with the record in the appellate court. The other side, the respondent, typically the party that won at the trial court level, files its brief. And then the appellant gets to file a reply brief. This is optional, but most appellants will file a reply brief in which they respond to the arguments in the respondent's brief. The case is then set a few weeks later for oral argument before a panel of judges. So one of the things that makes appellate litigation unique is that the cases are decided by a panel of judges rather than a single judge. And so the oral argument will be in front of that panel. In the federal system, it would be three judges. In New York, it's between 4 and 5 judges that make up the appellate division panel, 7 judges at the New York Court of Appeals. So the court hears oral argument, then issues a written decision, which you are familiar with because you've read many judicial decisions in law school. And then whoever loses the intermediate appeal can then try to seek an appeal to the next highest level court. Supreme Court of the United States or the highest state court if it's a state court. Typically, that's a discretionary decision. So the U.S. Supreme Court, except in a very few types of cases, does not hear every single party that wishes to appeal. Instead, they have discretionary, certiorari power to decide which cases it's going to hear. So how does moot court differ from the real world? Well, moot court is a interscholastic competition, and so that there are some significant differences to the real world. So the first step is the Moot Court Honor Society decides to enter a competition. Our team would then get assigned a side. They then will receive the case problem from the competition, and they will write their brief for the assigned side, then submitting it electronically or through the mail. They'll then begin the process of mooting or practicing for oral argument. One of the things that's unique about moot court is that you, in a competition, will argue both sides. So even though you wrote the brief for, let's say, the petitioner, at the competition itself, you will argue for both the petitioner and the respondent. You'll alternate sides depending upon the round. So it's important in the mooting process to learn both sides, not just the side that you wrote the brief on. So while you're practicing with your team at the competition, they're grading the briefs that they received from all of the teams. You then travel to the competition site, and there's a tournament-style structure to the oral arguments. So there'll be a certain number of preliminary rounds, and then you'll break. The top teams will break to either the octafinals or the quarterfinals, and then the semifinals, and then the top two teams in the final rounds. And then hopefully we bring home trophies for the awards given typically for both the briefs and for oral advocacy. One of the things that's important about moot court is that this part that I've blocked out in red. So from the time that you get the case problem through the writing of the brief, through the submission of the brief, all of this is done without any outside help. So this is just the 2 or 3 members of the team working together, but they're not allowed to seek outside help. So they can't typically contact professors or even other students or attorneys for any kind of assistance. But during the mooting stage, there you can get assistance. So just some words on terminology. I'll use the terms petitioner and respondent to refer to the side appealing and then the side answering or defending the appeal respectively, but other competitions or courts might refer to them as appellant or appellee. So in the real world, how do appellate courts decide cases? Appellate proceedings are not new trials. So appellate courts don't take testimony, for instance. So no witnesses would testify at an appellate court. Instead, what an appellate court is doing is reviewing the record, meaning the documents filed in the trial court and considered by the trial judge, as well as the transcripts of any testimony taken in the trial court. And what the appellate court is doing is trying to determine whether the trial judge committed some sort of error. And the key is to understand that there are different types of error. There's some errors alleged where it's alleged that the trial court made a factual finding that is in error. They found, let's say it's a car accident case, and they found that the light was red instead of green when the driver went through. On the other hand, there are legal questions that the trial judge might decide, and the appellant might argue that they were decided improperly. So whether summary judgment should be granted, or whether a particular statute is unconstitutional, or an interpretation of a particular judicial precedent. And we can think about standard of review is the extent to which appellate judges will give deference to the findings of the trial court. And you can sort of plot it out on a spectrum, as I've done here. There are some types of decisions where there's almost complete deference given, where the appellate court will not second guess the trial judge. Typically, factual findings are not going to be subject to review in the appellate court. Why? Because the trial judge was in a far superior position to make those factual findings. So the trial judge was the one who observed the witnesses, or the jury was the one that observed the witnesses and could ascertain whether they were telling the truth or not. In contrast, the appellate court, all they get is the paper record, or the written transcript of the hearing. And it's very difficult to tell whether somebody is telling the truth or lying just by reading a cold transcript. And so on factual questions, appellate court is often going to give complete deference to the appellate court. In contrast, legal issues, so whether a statute is constitutional or not, whether summary judgment should be granted or not, whether a motion to dismiss should be granted or not, these are legal questions. And the appellate court is in just as good a position as the trial court to make those kinds of decisions and to review them for accuracy. And so legal questions, there's no deference given. It's a de novo or brand new standard of review. And then there's everything in between. There's abuse of discretion and review for clear error. These are different standards that appellate courts determine based on the particular type of issue that is applicable. So it's very important to keep in mind the role of the appellate court versus the trial court. The appellate court doesn't want to step on the toes of the trial court when the trial court was in a better position, factual finding, an evidentiary issue, so forth, that they're in a far superior position to make than the appellate court. So let's move on to the second goal of this video, which is to understand the purpose and mechanics of oral argument. So the purpose of oral argument can best be understood by thinking back to the place in which oral argument sits in sort of the overall context of the appellate process. So remember that an oral argument takes place after full briefing. After the petitioner has filed their brief, the respondent has filed their brief, and the petitioner has filed a reply brief. And so there's been full written briefing of the issue already, and the judges and their law clerks have had those briefs for some time before the oral argument takes place. And so oral argument is really meant to be a continuation of the conversation that took place in the briefs. Now, we often don't think about conversations taking place in writing, but if you think about the order in which the briefs are filed, they really are kind of a conversation. The petitioner gives their overview of why they're right, the respondent responds, and then the appellant responds to the respondent. And so what you have is sort of a narrowing of the issues as you get then to oral argument. So the purpose of oral argument then is really to clarify some points that were made in the briefs. Perhaps there are some questions. Judges don't understand something that happened, or they don't understand an argument. Or the judges want to test the argument of the various sides. And not test in terms of quizzing the advocates, but instead trying to understand what the boundaries of the argument are, so that the judges can then write a thoughtful decision that does not set a bad precedent. So we know in our stare decisis system that appellate courts are very, very careful when they write opinions not to misstate or reach an erroneous conclusion and run the risk of that decision then setting a bad precedent for future cases. So a lot of what you'll see in an oral argument is really the judges trying to figure out, okay, how far should we go in reaching a conclusion here? So what's the order? How does this work in practice? So oral argument begins with sort of a ceremonial opening of the court. The court bailiff will make an announcement as to the judges are entering the courtroom and everybody stands. And then they'll call the first case. And the way it proceeds in moot court, in moot court, there are typically two issues to a problem. There are two issues in your Tinnelly competition problem, issue 1 and issue 2. And there'll be a total of 4 participants, 4 students participating. 2 for the petitioner, 2 for the respondent, 2 on issue 1, 2 on issue 2. So the way it works is petitioner's counsel, the student arguing issue number 1, goes first, presents their argument for typically 10 minutes or so, check the instructions for the Tinnelly competition to see how many minutes are allocated this year. And they'll present their argument on that issue only. Then the co-counsel, petitioner, the other student who will be arguing issue number 2, goes next. So the 2 petitioners go first. We call these P1 and P2. They are co-counsel, so they will sit together at one counsel table. And then the respondent goes, while the petitioner remains sitting. Then the respondent 1, will advance to the podium, deliver their argument, and then R2 will deliver their argument. The judges in moot court know this order. Nevertheless, if you are a P1 or R1, your introduction should indicate who you are representing and the name of your co-counsel and how you are dividing up the argument. So you could say, my name is so-and-so, and together with my co-counsel, and give their name, we represent the petitioner, the respondent. I will be addressing the first issue, which is, let's say, standing, and my co-counsel will be addressing the merits argument or the constitutionality argument or whatever it is. And so you have 10-minute chunks, 10-minute arguments. P1 goes first, then P2, then R1, then R2. In the real world and in other and in some moot court competitions, the petitioner would have a chance to deliver a rebuttal, typically 2 minutes or so. But for the Tinnelly competition, we don't do this. So we do P1, P2, R1, R2, and that's the end of the round. So 40 minutes in total. And then typically everybody will break character or break role, and the judges will offer critiques. So what is your presentation going to look like? What are you going to do for your 10 minutes while you're up there? Well, in theory, you're going to deliver first an introduction. We'll talk about what is contained in that. Next, you'll deliver a roadmap or a preview of your argument, basically summarizing your position. You're then going to have 2 to 3 main arguments that you're going to make to advance your position. Keeping in mind, both in real life and in moot court, the judges have read your briefs. Now, in moot court, they don't actually get your particular brief that you wrote. They get instead a bench memo that cues up the issue for the judges. But they will at least be briefed on the issue. So the presentation, your argument is not an introduction to the case. The judges are fully familiar with the issue. So what you're doing is you're really summarizing the 2 or 3 most important points for your case. And then you're delivering a conclusion. And all of that should be 10 minutes. Now, in reality, unless you have what we call a cold bench, you're going to get interrupted with questions. Most judges will allow you to get your roadmap out, but certainly once you start getting into your argument, you're going to start to be peppered with questions from the bench. And that's really the focus of oral argument, is responding to the judge's questions. But we'll get to that in a moment. Okay, so let's talk about questions from the bench. There are a couple of different types of questions that you might get. Factual questions. Where was your client when the police stopped him? Or what time of day was it? Real factual questions. So you really need to know the factual record to be able to respond to those. You might also get legal questions, like what is the standard of review here? Is it de novo? Is it abuse of discretion? Is it clear error? Or what's the standard for a motion to suppress? Or what's the standard for a motion for summary judgment? So purely a legal question. So you really need to know the legal standards in your case. But I think the most common types of question that you'll get is the hypothetical. So what if Mr. Smith was carrying a gun? Would the stop have been constitutional then? Or if the contract said X instead of Y, would the result be different here? Now, the judges don't need to be reminded in a hypothetical that this is not the facts of the case. So you never want to respond to a hypo by saying, well, judge, that's not what happened here. The judges know that. But so why are they asking a hypothetical? Well, they're doing it because they're trying to understand how far you want them to go in announcing a rule in this case. And they want to make sure that they're being consistent with their precedent. So that's really why they're pushing you with those hypos. So what are some strategies for conducting your oral argument? First of all, it's really best not to read. This should be an extemporaneous delivery. You should have an outline, and we'll talk about what you actually bring up with you to the podium, but you really shouldn't read prepared remarks. This is not giving a speech. Now, some people will read their introductions, particularly if they're nervous, and that's fine at first, but generally you don't want to read. You want to be extemporaneous. And the best way to prepare is by having notes in a manila folder. We'll talk about what that looks like in a few minutes. The advantage of a manila folder, and basically what it allows you to do is you have basically 4 sides to a manila folder, and so what you can do is you can tape or staple a piece of paper to each, and you basically have a little booklet. And the nice thing about a manila folder is you're going to be nervous up there at the lectern or the podium, and so the nice thing about a manila folder is you don't have papers flying everywhere, or you don't have this big unwieldy binder that might not fit up on the podium, and it just gives you enough basic information that you're able to refer to without it being too unwieldy. For oral argument, you're not trying to cover every possible argument. You're instead trying to emphasize your key points. Again, situate your oral argument in the context in which it appears, which is after full briefing on an issue. Think about the order in which your points are addressed. Is there some logic to them? Is there perhaps a threshold issue like standing or jurisdiction that has to be addressed first? You should assume the judge's familiarity with the record, so it's not necessary or even prudent to begin your oral argument with a summary of the facts. The judges know the facts. You can go right into your argument. Answer the judge's questions. There's nothing more frustrating for an appellate court than when the judge asks a question and counsel is evasive. You want to be very direct in your answers. Yes, Your Honor, because. No, Your Honor, because. Answer the questions, give an explanation, and then continue your argument. If you get multiple questions, which happens, sometimes judges talk over one another. The way to address that is to sort of look at both judges and answer with something like, Your Honors, if I may address your questions in turn. And then answer the first judge's question first and then the second judge's question second. That's a way that they'll sort of let you do that. That's a way of handling multiple questions. Be deferential. Use your honor. Start off your answers with your honors, or if you're answering a particular judge or justice, to say your honor. Don't use their names, even if there's name cards up on the bench, or even if you know them. It's very easy to get flustered and to mispronounce a name or to confuse two judges. You can't go wrong with just calling everyone your honor. Finally, and I know this is difficult, but relax. Be conversational. This is supposed to be a conversation with the bench, even though it seems very formal, and it is. There's a lot of pomp and circumstance associated with oral argument. You want to try to relax, and you want to try to be conversational as the judges are asking you questions. If a judge interrupts you with a question, that's a good thing. It gives you an indication of what that judge is concerned about. And so by answering that judge's question, you are helping the judge to understand and to figure out the case. And so you're really there in service of the appellate judges. And so be conversational, not informal. You don't want to have a very cavalier or informal attitude. You still want to be deferential, calling them your honor, but you want to try to relax. You want to try to be conversational. So let's talk about the actual outline for your oral argument. So what you want to do is you want to begin with a 15-second introduction. You're going to begin with, "May it please the court. My name is," fill in your name, "and I represent the petitioner or the respondent." This is also where you would identify, if you are P1 or R1, what issue you're addressing and which issue your co-counsel is addressing. You then want to have a 30 to 45 second roadmap where you state the purpose and also the relief that you're seeking. So, what it is that you want the court to do. Do you want the court to reverse? Do you want the court to affirm? Do you want the court to modify? What do you want the appellate court to do? And it's also your opportunity to introduce a theme. Perhaps your client's rights were violated, or perhaps the jury gave justice to your client by awarding your client a judgment, for instance. But whatever it is, introduce that theme, and then summarize your 2 to 3 reasons. And I'll give you an example of this in a moment. Then you would move into your 3 points that you've just summarized. And you can transition by saying something like, "Your Honors, as to my first point," and then go into it. But again, chances are you're going to start getting interrupted at this point. Don't get nervous or flustered if you do. Don't get worried, "Oh my God, I got to get back to my outline. If I don't go through all my 3 reasons, they're going to deduct points or something." That's not how it works. Again, look at questions from the bench as a real opportunity. And don't worry about going back to your outline. Only go back to your outline if they stop asking you questions. And then finally, you're going to have a conclusion or a wrap-up, and we'll talk about that in a moment. So here's a sample introduction. "May it please the court. My name is Larry Cunningham, and I represent the petitioner in this action, John Smith." It's at that point, if I was P1, I would also introduce my co-counsel. My co-counsel is, Jane Doe, and she'll be addressing the unfair sentencing issue, while I'll be addressing the prosecutorial misconduct or hearsay issue, whatever it is. I go on. "Mr. Smith was denied a fair trial." That's where I introduce my theme. "Because the trial court erroneously allowed the prosecutor to introduce unreliable hearsay and in the process deprive Mr. Smith of his constitutional right to confrontation." So that's my theme. "Mr. Smith asks the court to reverse the decision of the 14th Circuit for the following 2 reasons." So I've identified what it is I want to have happen here. Now I'm going to give my 2 reasons. First, that court applied the wrong standard of review. Second, the 14th Circuit failed to apply this court's decision in Crawford versus Washington, which held blah, blah, blah. As to my first point. So let's break this up. So the introduction is here in the red sentence. I'm saying, may it please the court, giving my name, telling who I represent. And again, if I'm P1, I'm also introducing my co-counsel. Here in green, I'm giving you the theme, which is denial of a fair trial because of a denial of the constitutional right to confrontation. Here in blue, I'm stating what I want. I want a reversal. And then I'm providing a roadmap. I'm giving the 2 reasons for why I should win. So that's just a simple introduction. You can copy this and apply it directly to your case. So before I get into the conclusion, let me just talk a little bit about the Manila folder and how helpful it is. So again, you think about a Manila folder almost like a little book. You have the cover, you open it up, you have the left page, the right page, and then you close it, and then you have the back cover. And so that's 4 different places you can put 4 different things. What I typically do is on the front cover, I'll put my introduction. I'll write that out, including my name. You wouldn't believe how many times students blank on their own name when they're up there doing an oral argument. So actually write out, may it please the court, my name is, and write your name and write out the full introduction, knowing that you're going to have that memorized and you're not going to need to refer to it. Then on the in the inside pages, so as you open up the folder, here you put kind of summaries of your 3 points in nice big font. That's really the key. Make it like 16 point or something. So you could see it very, very easily when you're up there at the podium. You're not going to have the time to really look at lots and lots and lots of detail in very small print. That's not going to be helpful to you. Instead, kind of have your 3 points listed out, perhaps with some bullet points, perhaps with some names of cases, with page numbers of the record that you can refer to if needed, and do that for each of your 3 main arguments. Then on the back page, what I like to do is have sort of short 1-line summaries of all of my key cases or statutes, the key authorities that I'm relying on. So if a judge does ask me something about the Jones case, and I momentarily blank on the Jones case, I can just turn my Manila folder over. And again, what I do is I print out 4 different sheets of paper. I type out what I want on these 4 pieces of paper, and then I staple them to the Manila folder. It's not going to be anything pretty, but the nice thing is the papers don't go anywhere then. As opposed to if you have them kind of loose and they have the possibility of kind of flying all over the place. Okay, so you have your introduction, you have your roadmap, you're then maybe starting to do your argument, but then you're starting to get questions from the bench and you're answering them. And you see that as a positive thing. But at some point you're gonna reach the end of your argument. Now, oral arguments are timed. You're given a set amount of time. The instructions for this year's Tinnelly competition will be in the packet as to how much time you get. There'll be a timekeeper who will give a certain countdown. Maybe when 2 minutes are left, they'll put up a 2-minute sign, and then 1 minute, and then time. So you'll be able to kind of keep track of the argument as it goes along. But no matter what, you want to have a canned 1 or 2 sentence conclusion that really emphasizes the relief that you want. So you could say something like, accordingly, because my client's confrontation clause rights were violated, this court should reverse the decision of the 14th Circuit. Short, sweet, to the point. Now, what happens if you run out of time while you're answering a question, which is not uncommon at all? So if you see the time card goes up while you are answering a question, you must immediately stop mid-sentence. You then turn to the Chief Justice, who is in the middle of the bench, and you say, Your Honor, I see that my time is up. May I have leave, meaning permission, to finish answering the question? Typically, the chief will say, yes, I'm granting that permission. You then finish your answer to the other judge's question, look at the bench and say, thank you, and sit down. In other words, you do not deliver your canned conclusion. Your canned conclusion is only if you have not run out of time while answering a question. Or if you run out of time while making a point, it's okay to ask for leave to conclude instead of asking for leave to finish answering the question. Let's say it's a pretty quiet bench and you're making, let's say point 3 of your argument, and you see that time has gone up. Again, you have to stop mid-sentence, but rather than awkwardly just sitting down, you can look at the Chief Justice and ask for permission to conclude briefly. Often I will say that, may I have leave to conclude very briefly, Your Honor? And typically the Chief Justice will say, yes, very briefly, go ahead. And then you want to deliver that one sentence conclusion, say thank you, Your Honors, and sit down. So what you want to do is you kind of want to practice this. Once you do this a couple times, it sort of becomes second nature. The key is that when time is up, your time is up. And if you want to go beyond that, that's the court's time. And so you have to have permission of the court to sort of intrude on their time. If you're looking for some examples of moot court oral arguments, just search on YouTube. A lot of them are now recorded and posted on YouTube. Just search for something like moot court oral arguments, and many competitions will post them online. So, for example, Harvard has a very famous moot court competition called the Ames Moot Court Competition, and they have the video archives online, and you can watch them and get a little bit of a better sense of that. So I hope you found this helpful. I encourage you to re-review this presentation. The PowerPoint slides will also be available. Don't reinvent the wheel with respect to the introduction. You have the introduction and the template for it. Use that, and then you can adapt it as you start getting better. Think about your roadmap. Think about the 2 to 3 points that you're going to raise, and think about how you're going to respond to questions. As you prepare, think about what kinds of questions would I ask if I was on the judge and I wasn't sure how I was going to rule. That can give you an idea of what questions you might be asked, and then think about how you would respond to them. Overall, have fun with it. Moot court can be intimidating, but oral argument can be a lot of fun as well. If you really look at it as a conversation with the bench, that you're there to help the judges make an informed decision, it becomes a very enjoyable and worthwhile process. And I wish you all the best of luck in the Reverend Joseph T. Tinnelly Moot Court Competition at St. John's.